Every day across America, thousands of legal complaints are filed. The vast majorities are typed, bound, and presented by attorneys, professionals who have spent years of mastering the labyrinth of civil procedure, statutory interpretations, and the unspoken etiquette of the courtroom. They wear the suits, they speak the Latin, and they operate within a system built by lawyers for lawyers. But every so often, an individual decides to bypass the gatekeepers. They pull up a chair to the counsel table completely alone. In the eyes of the court, this person is known as the pro se litigant, a Latin phrase meaning for oneself. And in Geauga County, Ohio, one specific pro se litigant has taken that solitary courtroom experience and transformed it into a digital broadcast. And welcome back. Today we're exploring a digital footprint that has been steadily expanding across Northeast Ohio. We are peeling back the layers on the platform known as the Chardon Pro Se, operating via audio podcast on platforms like Podcast Addict and updates on Facebook. The creator behind the microphone offers a raw, unfiltered diary of what happens when a citizen chooses to wage war with a multi-year, multi-tiered legal battle against an established organization completely on their own. But this isn't just a localized story about local grievances. As we will track today, this journey started in the Geauga County Court of Common Pleas, climbed into the Ohio Court of Appeals, knocked on the door of the Supreme Court of Ohio, and is now attempting to breach the highest legal barrier in the land, the Supreme Court of the United States. This is the anatomy of a pro se crusade. To truly understand the Chardon Pro Se, we have to look at the modern phenomenon of the independent creator. Historically, if you had a grievance with a local judge, law enforcement agency, or a major corporation, your battle stayed isolated. It lived in a dusty filing cabinet in a brick-and-mortar courthouse. Unless the local newspaper happened to have a reporter sitting in the gallery that morning, your struggle was completely invisible to the public. Technology changed the math here. Today, a smartphone is a printing press and the RSS feed is a radio tower. For the Chardon Pro Se, the microphone functions as a secondary court of equity. In his episodes, he doesn't just recap what happened in the court, he dissects the mechanics of the governance. He openly critiques local judges, challenges the courtroom procedures, and calls out what he perceives to be the structural bias within the Geauga County legal system. But why do people choose this path? Legal scholars often point out the navigating of the civil justice system pro se is an uphill battle of monumental proportions. The rules of evidence do not bend because you don't have a law degree. Judges are strictly bound by neutrality. They cannot act as your counsel or fix your procedural mistakes. To the legal establishment, a pro se party is often viewed with skepticism. Some prone to filing overly complex, emotionally driven paperwork that clogs the docket. But to the pro se creator, the calculation is entirely different for them. It's about the institutional transparency. It is the belief that the law shouldn't be a closed shop. By documenting the setbacks, the procedural dismissals, and the hostile exchanges, creators like the Chardon Pro Se attempt to demystify and hold accountable a system that they feel is designed to shut them out. To understand how high these stakes can get, we have to look at actual legal battleground. Let's look at the case file that has driven much of the narrative, case number 2025G-0010, officially styled as Wesley Redding versus United States Parachute Associating. This isn't a minor overnight dispute. This is a complex civil litigation that has spanned several years, originating from a deeply rooted conflict. The core of the initial complaint dates back to allegations regarding wrongful denial of Redding's membership renewal with the United States Parachute Association, or herein USPA. When you dive into the appellate records from the Ohio 11th District Court of Appeals, you begin to see how a personal dispute quickly snowballs into a massive structural warfare. Redding, acting as his own counsel, leaded a massive array of claims against the association and the association's associated individuals. We are talking about allegations ranging from breach of contract and negligence to intentional interference with a business relationship, and even claims under the Sarbanes-Oxley Act. But fighting a well-funded organization means facing corporate defense attorneys who know exactly how to deploy the civil rules of procedures. The defense moved for what was called a judgment on the pleadings under Ohio Civil Rule 12C, which essentially means they argued that even if everything Redding claimed in his paperwork was true, it didn't amount to anything legally recognizable violation that the court could remedy. The Geauga County Court of Common Pleas agreed and dismissed this action. But that blow didn't stop there. The trial court went a step further, awarding the USPA sanctions and attorney's fees against Redding, ruling that his filings constituted as quote-unquote frivolous conduct under Ohio law. For most people, a financial sanction and total dismissal from a local judge would be the end of the road. The financial risk alone would force a retreat. But for Wesley Redding, it was the signal to climb higher. He appealed the decision to the 11th District Court of Appeals, challenging this dismissal, the sanctions, and the conduct of the lower court itself. On October 6, 2025, the appellate court handed down its decision. In a detailed opinion authored by the justices, the court affirmed the lower court judgments across the board. They ruled that the USPA had followed its internal manuals, the Redding statutory claims lacked applicability, and the trial court's awarded of the sanctions for frivolous conduct was legally justified. In an American legal architecture, an appellate court's decision is a massive roadblock, but it's not technically the final stop. If you believe in an appellate court misapplied the law or that your constitutional rights were violated, you can file a jurisdictional appeal with the state's highest court. And that's exactly what the Chardon Pro Se did. He took the fight to the Supreme Court of Ohio. For a pro se litigant, submitting a brief to the state Supreme Court is like trying to land a plane without instruments. The formatting, the jurisdictional statements, the precise legal questions presented, everything must be exact. More importantly, the Supreme Court of Ohio is the discretionary court. They do not have to hear your case. Out of thousands of appeals filed to them every year, they only accept a tiny fraction, typically cases that involve matters of major public interest or unresolved constitutional gridlocks. When Redding's case arrived, the judicial reviewed the filings. The decision was swift. The Supreme Court of Ohio declined to accept jurisdiction, refusing to review the case and leaving the appellate court's ruling and the financial sanctions completely intact. At this juncture, 99% of the litigants stop here. The state has spoken. The legal remedies within the boundaries of Ohio are completely exhausted. But the Chardon Pro Se's identity is built on pushing past the boundaries where others turn back. With the state's courts locked shut, Redding has set his sights on the ultimate apex of American law, the Supreme Court of the United States in Washington, D.C. Now, to understand exactly what Redding is trying to do next, we have to talk about another piece of legal Latin. To get your case in front of the United States Supreme Court, you cannot simply file a regular appeal. You have to petition the court for a writ of, I may mispronounce this, but certiorari, often referred to in legal circles simply as cert. So what is exactly certiorari? The word originates from Latin, meaning to be more fully informed in practice. A writ of certiorari is an official order issued by a higher court to a lower court, demanding that they send up the entire record of the case so it can be reviewed. But here's the catch. The Supreme Court is under absolutely no obligation to grant this writ. Under the rules established by the Judiciary Act, the Supreme Court operates almost entirely on a discretionary review. They get to, on one hand, pick their docket. To get your petition granted, you have to clear a hurdle known as the Rule of Four. When a petition for cert arrives, it is reviewed by the justices and their clerks. A case will only be accepted if at least 4 of the 9 Supreme Court justices vote that the issue is important enough to warrant their time. And you ask, what are they looking for? They aren't looking for minor judicial mistakes. The Supreme Court does not care if a local judge in Chardon, Ohio made an error in calculating attorney's fees or interpreting a standard contract. They look for what is called circuit splits, situations where different federal appellate courts have interpreted that the U.S. Constitution or federal law in completely opposite ways. They look for massive, sweeping constitutional questions that affect the entire nation. Think about a sheer scale of this gatekeeping. The United States Supreme Court roughly receives 7,000 to 8,000 petitions for writ of certiorari every single year. They grant a cert to about 80 of them. That's a massive, massive number compared to what is actually received. It's just minuscule. This is roughly a 1% acceptance rate. The odds are astronomically against even the most prestigious corporate law firms and constitutional scholars in the country. For a self-representative citizen typing out their own petition, submitting a packet to the Supreme Court clerk in Washington is the ultimate legal long shot. Yet, it highlights the core psychology behind the Chardon Pro Se platform. It is the refusal to accept the finality of the lower court's gavel. So, what do we make of the Chardon Pro Se? How do we contextualize this long, exhausted paper trail stretching from local county courtrooms all the way to Washington? If you speak to legal traditionalists, they will tell you that cases like Redding v. USPA are cautionary tales. They point to the court-ordered sanction as proof that navigating the law without a professional guide can result into severe financial and legal penalties. They argue that the rules are there for a reason, and failing to respect those rules disrupts the efficiency of the justice system. But if you look at it through the lens of a citizen journalism and the internet culture, you see a completely different narrative here. You see a public record of endurance for the people who follow the Chardon Pro Se on Facebook or listen to the podcast audio on rss.com. The value isn't necessarily in whether he wins or loses a specific civil motion. The value is in the exposure of the process. It exposes just how difficult, how expensive, and how alienating that the legal system can be for an ordinary person standing alone. It shows the grit required to look at the wall of the adverse rulings and say, I'm still typing, I'm still filing, and I'm still broadcasting. Whether his petition for certiorari is rejected, miraculously reviewed. The digital archive remains. The audio episodes are still online. The court transcripts are immortalized in the public domain. Long after the dockets are closed, the Chardon Pro Se has ensured that his battle won't be fought in the dark, or hasn't been fought in the dark. The wheels of justice grind slow, but the microphones of the internet record fast. You can keep tracking this ongoing story by searching for the Chardon Pro Se on your preferred podcast directory, or checking out their local updates online. Thanks for stepping up to the council table today with us. Until next time, keep questioning the fine print. Directory, or by checking out his local Facebook page online. Thanks for stepping up to the council table with us today. Until next time, keep questioning the fine print.